Good afternoon. We're on record on the Kelsey Fitzsimmons matter, docket 2025-77 CR 311. All counsel and the defendant are present.
Thank you. So, before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this, this is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And so, as the lawyers know, unlike when a judge presides over a jury waiver trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Newman, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard to perform their solemn jobs fairly with the utmost civility and professionalism. They serve as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving promotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, Our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following three things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Newman. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these three elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Newman for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Newman's use of force, and issues regarding the custody of Katie. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Newman and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Newman. On the other hand, Officer Newman testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Newman's left. The door frame was also made, the door frame was made still narrower when Officer Newman used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Newman shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Newman, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed assault by means of a dangerous weapon on Officer Newman, and my verdict is, and it must be, not guilty. With that, I will hand the signed verdict slip. I will hand the signed verdict slip to Mr. Wayne and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders it to be discharged of this indictment, and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you. Court is in recess. Good, all right.
Please exit quietly, and thank you once again. Thank you. Folks, there are other sessions still going. Please be quiet on your way out. Folks, if you don't mind, just stop looking over to the back door here. Also get out. Tight space here. Folks, make your way out. Say that again, Jay. Courtroom 1, social still. Everybody should be tripling out. Some of you guys want to start going down so that we can get people moving.
Down here, front door, second.
Folks, I don't mean to put speed to what you guys going on here, but we have other places we need to be as officers. So, please. You guys are more than welcome to use that room. You guys can use in there. Be brief.
Yeah, because I need to get this stuff.
You have an opportunity to be up. We'll have at least an officer here, so you can take it.
What do you want to talk about?
We're just gonna go back to that conference room.
The same one we were just in?
Yeah.
That's not on, right?
Amen.
See you later.
Let's go. Let's go. All right.